In addition, the DPP will be seeking that each of the accused persons who is in possession of a passport deposits the same in court, and whenever they would like to leave the jurisdiction of the court, they should do so with the permission of the court. Further, there should be no contact or interference with witnesses once they have been served with the evidentiary material that the prosecution intends to rely upon. Lastly, Your Honor, none of the accused persons, and this also applies to my colleagues, should make any comments outside this court regarding this matter. Now that the court is properly seized of the matter, any comments regarding this matter should be made in court so that we preserve the integrity of these proceedings. That will be all from the DPP. Your Honor, perhaps then you can guide us on the issue of disclosure.
Okay.
Thank you.
Defense, yes, Mr. Peter Wanyama.
Yes, Your Honor, we will be very brief in our submissions. We thank the ODPP for their statement that they are not opposed to bail. If bail is a constitutional right, there are no reasons compelling why they should not be released on bail. On our part, we request that you release them on reasonable bond or terms of cash bail, reasonable cash bail, for the following reasons. Despite the fact that the accused persons have been charged with 27 counts, if you look at these charges in the context of a normal and usual anti-corruption prosecution, which this court is seized of, you will see that there is no single officer from the county government of Bungoma, from the procurement department, or finance department, or within the department, in this case the accounting officer, who has been isolated and charged with any offense in relation to what the state has brought to court. That is very significant. Significant because they are the ones responsible for the procurement and payment. What that means on the face of the charges is that there is no irregularity on the procurement and payment process. Because that's what the charges, they ought to speak for themselves. Secondly, our argument is stronger, again, because there is no officer from the county government, including the first accused person who is present before court, who has been charged with abuse of office. Your Honor, that is very significant. Ordinarily, in an anti-corruption prosecution, abuse of office will be the first charge against the former governor of the county. But there is no evidence, no threshold, no iota of evidence whatsoever from their own charges why to lay basis for the first accused person, Wycliffe Wangamati, to be charged with abuse of office. That is very significant. Again, there is another charge which is usually present in 100% of all the charges: conspiracy to commit a corruption offense. Again, it is not present in these charges. There's no conspiracy at all. So again, that is quite telling. Additionally, if you look at the way the charges have been crafted, even though they have been broken down, Your Honor, but there is one fundamental issue which the accused persons have desperately tried to explain to EACC in vain, that these were all subcontracts, and we will be maintaining that throughout the hearing of this case, that they were subcontracts. There is no nexus between, in the law of subcontracting, there is no nexus between the county government and these contractors at all. So they were all subcontracts. So, but EACC has declined to listen to that defense. The accused persons really tried to explain why you will see these documents which they mention in the charge sheet belong to other institutions, other agencies, the county government of Tana River, etc. Because these documents were lawfully issued to the subcontractors by these agencies, county governments, and they were put together for tendering purposes. So, but that is a matter for the trial. We will deal with it at the right time. But on the severity of the charge, we just wanted to have that picturesque perspective so that you can see, whereas the counts are many, the charges are really, even on the face of it, explainable. In relation to the cooperation of the accused persons, you want to allow me to say that it's really important, Your Honor, that the court notes that the accused persons have really cooperated with the EACC. Your Honor, this is significant because when the DPP last week issued a press statement that they will charge the accused persons with a crime, the accused persons realized a major mistake which has been made by the EACC and DPP. They had recommended charges against a gentleman known as Nicholas Wanjala Wangamati. The person we submitted documentation, they said that they want to arrest this person, bring them to court. So we asked, we submitted documentation showing that the person actually passed on 3 years ago, unfortunately. And that explains why Nicholas Wanjala Wangamati has been removed from the charges, which despite the DPP's notification to the public, Nicholas has now been removed from the charges that are before court. That came from the accused person. And we are just asking what other information positive the accused person could have given and considered favorably. There's a lot, but we'll cross that bridge. In relation to the first accused person, the first accused person faces a charge known as conflict of interest. Former governor of Bungoma, Wycliffe Wangamati, faces a charge conflict of interest. Again, you will see from the characterization of the charges, and evidence will confirm this, that the state has really tried to get the first accused person in court. They have really tried.
Mr. Wanyama, are you going to the merits of the case?
No. I'm just saying, Your Honor, for purpose of severity of the charge, because it's a factor.
Sound like an opening statement.
Yes, Your Honor.
Yes.
It is a factor. Actually, I'm responding to Monda when Monda says, "Look at the seriousness of the charge." Ours is that no, you need to look at the context, and Your Honor, that I think will be the far we can go. We can't go beyond that. Your Honor, there's an additional issue that we wanted to raise also in relation to an accused person. Bramwell is present before you. Actually, EACC gave him a special treatment because he is not well. He's not feeling well. EACC has accorded him a special.
What number of accused? C7.
He's accused person number 7.
Okay. Mukewa Wafula.
Yes, Your Honor. And Your Honor, in terms of that argument on flight risk, you can just see for yourself. There is no, apart from that issue of compassion because he's in a wheelchair and he suffers from serious hypertension. He's not a flight risk at all. He's one of the accused persons who myself, Your Honor, I would recommend that we release him on a free bond. He will attend court, but he's suffering from serious health, serious and massive health constraints. We tried to ask him if he can delay the plea, but he said he will struggle to go through the plea process. You honor the statement that no one shall comment on the charges that are before court applies both to the state and to the defense. Your Honor, both the EACC and the DPP, they are obligated to abide by that statement because they are the ones whipping out the emotions by issuing press statements. But now that the matter is in court, we hope they will refrain themselves. The defense will undertake that we will not make any comments, especially for us lawyers. We will not make any comments because it is a bit prejudicial. It's always prejudicial if we are commenting on a matter which is pending before a court of competent jurisdiction. Again, we undertake as the defense for the accused persons who hold the Kenyan passport or any travel documentation, we will deposit that in court, and no accused person will travel out of the country without the permission of the court, which will be sought usually, I think for only one accused person, but we will cross that bridge. One accused person who has that is Edward. Is it Edward? Yes. For Edward, we will be seeking permission because he has some businesses out of the country. But if he wants to travel, Your Honor, we will come before you and we seek adequate permission, and we will notify the state accordingly. And lastly, Your Honor, we would like to say that we are thankful and we undertake to fully cooperate as the defense throughout this prosecution. And we will sincerely request that you accord the accused persons reasonable cash bail term and bond terms. My colleague, Mr. Edward Wangila, is going to make an additional argument on why that is necessary. Thank you, Your Honor, with your permission.
Mr. Wangila?
With the permission of the court, Your Honor, on the application for bail, our request is that you grant us reasonable bail as already submitted by my colleague. And we'll be submitting that you grant an amount not exceeding 50,000 shillings. And Your Honor, the basis for that particular submission is that you'll not, or just to inform the court, Your Honor, the first, second, and third accused persons are brothers. And the fourth accused person is a niece, sorry, a nephew. The fifth accused person is their niece. The sixth accused person is a nephew. The seventh accused person, Your Honor, is a cousin. The eighth accused person, Your Honor, is also a cousin. And I think it's those ones, yes, Your Honor. So the reason I'm raising this, Your Honor, is that whichever resources are going to be utilized in settling this cash bail, once granted by the court, because we already know it's not opposed. is, you know, there are family resources. So we must take into consideration that we wouldn't want to strain one family from, you know, having to take the heavy task of raising cash bail that would be relevant for these proceedings. On the other issue, Your Honor, you'll note from the charges, there is no accusation, there's no accusation that there's been loss of any public funds. So matters, there have been a lot of numbers that have been thrown in the charges that have been presented before the accused persons. You'll note, Your Honor, that there is no allegation whatsoever that there is loss of public funds. So we are saying that even when you retire to make your decision on the bail applicable, we ask you to take that into consideration. The critical thing is that we don't want the accused persons to appear like they're already convicted at the point of cash bail. We ask you to exercise your discretion in a manner that will ensure that they can attend court and that we've already submitted. They're also not flight risk. I think that will be the only other addition to our application for bail. That's all, Your Honor.
Yes, Your Honor, in the interest of time, I wish to